My name is Rachel Kitsy Collins. I'm an attorney at Lockridge, Grindle now and co-president of the Minneapolis-St. Paul chapter of the American Constitution Society. Thank you so much for joining us today for this event about what every lawyer should know about the future of transgender student rights. We have many co-sponsors today who I'd like to thank. First, the Best and Flanagan Law Firm, Gender Justice, the Minnesota Department of Human Rights, the ACLU of Minnesota, and the Office of the Minnesota Attorney General. In addition, I'd like to thank Katie Barrett-Wick, a partner at Best and Flanagan, and Minnesota Court of Appeals Judge Jeff Bryan for all their work putting this event together, along with our panelists. Before I introduce our moderator, I'd just like to flag two upcoming events. First, next Thursday, September 30th, ACS is hosting its 6th annual Progressive Law Benefit. The event starts at 5:30 at Dayblock Brewing. We have a great list of luminaries who are going to be there, and I'll put the link in the chat to register. Second, on October 6th, the ACLU of Minnesota is hosting its annual fundraiser breakfast virtually starting at 8 a.m., and I'll put that link in the chat as well. Before we start, this event has been approved for 1.5 CLE credits. I'll put that number in the chat. And I'd now like to introduce our moderator. Amy Connors is a partner at Best and Flanagan. She's an experienced litigator and has represented clients from global Fortune 100 corporations to individuals on a wide range of legal matters. She's also the ethics lawyer for Best and Flanagan and serves on its executive board. She has experience in criminal defense, complex commercial litigation, and professional license defense. She's a graduate of New York University School of Law and began her practice in New York before returning to the Twin Cities. She has also served as the co-chair of the Minnesota Lavender Bar Association, has been recognized as a rising star and super lawyer, and an up-and-coming attorney, and one of the best LGBT lawyers under 40 by the National LGBT Bar Association. So I will turn it over to Amy to get us started. Thank you.
So much, Rachel. Thanks to everyone for joining us. I will introduce our panelists and just get right to it so we can jump into what we all came here to discuss today. So first, I'd like to introduce Jess Braverman. She's the legal director at Gender Justice, where she ensures their litigation strategy not only for the dignity of clients, but also for their mission of removing barriers to gender equity. Jess came to Gender Justice from the Hennepin County Public Defender's Office. And after representing hundreds of clients in felony matters in the 4th District, she spearheaded the office's special litigation unit, where she focused on racial profiling and policing. Jess attended NYU Law School, where she was the Arthur Garfield Hayes Civil Liberties Fellow with a focus on LGBTQ rights. After graduating, Jess worked at the Legal Aid Society's Juvenile Rights Project, representing young people in delinquency and child protection cases in Brooklyn, New York. Next, we have, Cheryl Green, who is the director of Welcoming Schools. Cheryl has spent her career in education and is passionate about bully prevention methods and helping to create classrooms where all children can thrive. Under her leadership, the Welcoming Schools program trains and equips outstanding facilitators across the country to provide professional development, support, and resources aimed at making elementary schools welcoming for all students and families. Cheryl was a classroom teacher, a school leader, and a basketball coach for over 2 decades before joining Welcoming Schools. During that time, it became clear to her that until students feel safe, respected, and valued, very little learning occurs. Cheryl's married to an amazing woman, and together they have 4 wonderful children. And finally, David Paul Mckinney is a seasoned litigator who left private corporate practice several years ago to work for the ACLU of Minnesota. He leads a team of lawyers and other advocacy professionals in developing and executing impact litigation, legislation, and community engagement strategies to defend the First Amendment, to protect minority groups, expand voting rights, and reform the criminal legal system. David's recent efforts have specifically included advocating for the rights of transgender students and their families, like in the NH versus Anoka-Hennepin School District case. His legal and community work has been recognized by a number of organizations, including Top 40 by the National Black Lawyers, Up and Coming Attorney by Minnesota Lawyer, and Rising Stars by Super Lawyers. David is a first-generation college graduate with a bachelor's degree in ethics and business management from Crown College, a master's degree focused on ethics and religion, from Trinity Evangelical Divinity School and a law degree from Loyola University Chicago School of Law. He's a native Chicagoan, lives with his wife, 8th grade daughter, and their golden doodle in the Twin Cities. And that is the best kind of so, let's get right into it. And what we thought we'd do today, I'll just give you an overview. We are going to kind of focus from a 35,000 foot view on best practices on gender and children in schools. If that's not a wide topic, I don't know what is, but we'll try to just give you some grounding in that. Then we're going to go through and talk about trans kids in Minnesota, the Minnesota legal landscape, and then we'll widen our lens again and talk about the national landscape, and then talk about kind of trends we're seeing going forward. So Cheryl, why don't you start us off? And we're just going to make it really easy for you. Can you give us kind of a brief overview of some of the best ways to create a gender inclusive school environment?
Absolutely. Thanks for having me. And I'll start with, I'm not a lawyer. I'm an educator. And I think it's fitting and it's interesting that you're having me go first, because if educators work to truly create a gender inclusive classroom proactively, we reduce the need for legal intervention. So I'll say that the best way to create a gender inclusive school for students is to ensure that educators have both the competence and the confidence to create those environments where students are not limited by gender roles, by stereotypes, by expectations. And I would like to think we work with schools all around the country. And I would like to say that most educators want to do the right thing, and they just don't know how to do it. We get calls so often from administrators and educators saying, we've got a kiddo that's trans or that wants to transition. What do we do? How do we do this? How do you help us? And so the first piece is for educators to gain that core knowledge. What's gender? What is gender? How do we define gender outside of this binary concept? How do we talk about gender terms to younger students? And newsflash, they get this better than the adults do. We know that. So we need to move the needle with educators before we can expect them to then create the environment that we expect for students. So once we have that foundational knowledge, we can move into how. So how do you do that? When we, as a program, I run a program called Welcoming Schools. So when we work with staff, we start with the basics and then move into, so what strategies can you incorporate to create an inclusive space? And then we do some role playing on building confidence, because we know what kinds of questions come up from students, from families. And then we can gain both, like I said, the competence and the confidence. So if you want me to just move into more specifics, I can do that. So what does that really look like? What does a classroom that's gender inclusive look like? So you have educators that are using inclusive phrases to address their class. Instead of saying boys and girls or guys, they're saying, hey folks, hey students, other ways to address the class outside of it being binary. They'll group students in ways that don't rely on gender. In elementary school, lining kids up, boys over here, girls over here. Later on, graduation, having kids, the boys wear this color, the girls wear this color. Having books that they read and lesson plans that help break down those gender stereotypes and showcase the many ways of being who we truly are. Classrooms and hallway signage that sends a really clear message that all students are valued. And educators early on in elementary school not making assumptions about who's in their family. So referring to students' family without saying, bring this home to your mom and dad. I heard something recently, somebody saying your grown-ups or the people that you live with or your family. So not making those assumptions about family. I think the bottom line is that we know when students feel safe to express all of their identities, they'll be more prepared to learn and thrive in school.
Thanks, Cheryl. Can you talk about some of the, specifics that where schools might encounter this? And I'm thinking of dress codes at certain schools. You mentioned that a little bit. The preferred names and pronouns of kids. What are best practices for schools to have policies that anticipate that and welcome all kids?
Sure. I think one of the most important ways to show students you value them is to use the names and the pronouns that they ask you to use. There's been some recent studies, and we know that the risk of both depression and suicide ideation in youth that are called the names and pronouns that aligns with their gender identity is significantly lower. So using the names and pronouns that they're asking you to use. It's easy enough to do. It doesn't even have to be something that's in the legal system. It should just be in your classroom, how you refer to them. Kids tell you they go by shortened names all the time. So use a name that aligns with how they want you to address them. Dress codes, and I'll leave the legal stuff to the legal folks, but best practices around dress codes is that dress code should apply to all students, period. A dress code should never target specific identities, whether that's gender or sexual orientation or race or religion or any other aspect of an individual's identity. So, what we help folks do is review their dress codes to make sure that whatever those dress codes are, that they apply to all students rather than enforcing gender stereotypes, which typically tend to be with girls. So anything that enforces dress codes more strictly against one gender, obviously that doesn't work well. And ensuring that those dress codes apply to both regular school days and also special events like dances and proms and graduation.
Thanks. Talk about your work with welcoming schools, particularly helping schools address what we're going to talk a lot about today, but sort of like hot button issues like locker rooms, access to bathrooms, access to gym class, those kinds of things where we're seeing the flashpoints in litigation. What do you as an educator go in and tell schools about and recommend when it comes to those sorts of things?
Again, I think it's about proactively setting the stage for students to be who they are instead of reactively responding, where then you need to bring in folks like gender justice. So if we can set the tone early for, let me go back and talk about like what I think has to happen before we look at, locker rooms and bathrooms. I think the key to what we do is to look at bullying and to look at this from sort of a larger scale. So the best practices we think to address bullying is to take a step back and think about what is causing bullying in the first place. So I will say that most bullying is caused from some sort of bias, right? So in elementary school, much of the bullying occurs around gender and gender stereotypes and what a boy should look like and what kinds of things he should play with and how he should act and how he should dress and what a girl should look like and act like and play with. And so much bullying occurs because of that. So if we can take a step back and create an environment where that doesn't occur in the first place, you're going to eliminate much of the bullying from happening in the first place very early on. We did some research on some schools in Minnesota in a district where there were 10 schools, all of them with similar demographics. We did welcoming schools, proactively creating gender inclusive environments in 5 of the schools, looked at data prior to working with them, discipline data specifically around bullying events, and then looked at these 5 schools compared to the 5 schools that hadn't done welcoming schools, and their discipline around bullying had decreased from like 30 to 50%. Not because they were reacting in a way that was better, but because they were setting the stage proactively where it wasn't happening in the first place. And that's really where you're going to see some shifts in this, right? And then as we move into then talking about locker rooms and you're talking about bathrooms, if there are no issues with the kids, you're not going to have those issues in the long term.
That's a really helpful way of looking at it. And you have kids, as do I. I think I can also say, are you seeing this? Kids are far ahead of maybe where educators are now, and it's like a different world. So what are you seeing in terms of kind of that educating staff and teachers and administration versus kind of where the kids are in terms of what they're expecting and where they are just as like their own generation?
Right. Well, we are never going to be where they are. And even as a facilitator and somebody that does this work, like I'm always learning new things about different pronouns outside of, your pronouns that we may be familiar with, neo pronouns and things that, I'm needing to learn. And I guess what we try to get educators to realize is that you don't have to know all of this. You just need to listen to kids and believe them when they tell you something, and believe them when they tell you who you are, and then take their lead. That's you don't have to know, and you don't have to know everything. You do need to listen and take their lead is where we try and get educators to move to.
Great. Well, thanks so much, Cheryl. And just administratively, I should have said this at the outset. We would prefer if you can use the Q&A portion of the chat. I guess it's a different version. We're having somebody monitor those, and that'll be the best way to get questions to the panelists. I'm happy to take those as we go along. The chat is just a little bit too hard to manage right now. So if you can migrate any questions you have to the Q&A portion, and we'll try to get those answered as we go along, and we'll also have time at the end for questions. So, but I hope to have active participation throughout this. Well, let's move and talk about kind of what we know about trans kids and non-binary kids in Minnesota. And Jess, maybe you could talk about this. In Minnesota, we have a student survey that's given pretty regularly. Can you talk about that, the Minnesota survey, and explain what that is?
Yeah, absolutely. Thank you, Amy. And thank you also, Cheryl and David. I want to echo what Cheryl said, hiring an organization, working with an organization like welcoming families, welcoming schools. It may cost money, but it's definitely less expensive than being sued by Gender Justice and our partners, ACLU, Best and Flanagan, Nichols Castor, and others. And we're going to talk about that because it's actually real. There have been real consequences for schools not being proactive. But the Minnesota Student Survey is one of the longest running youth surveys in the nation. It started in 1989. It'll next be administered in early 2022, so between January and June. They send out questions to students. This is going to be administered to kids in grades 5, 8, 9, and 11. Not every school participates, not every kid participates, so it's based on who's participating in the survey, but there's a pretty high response rate, and it collects a lot. It's really unique. It collects a lot of data, and it collects a lot of cross sections of data, like, are you transgender or genderqueer? And if so, are you bullied? Are you, it really is just like a wealth of information. In terms of trans and non-binary students, based on at least the Minnesota Student Survey, they do ask questions about gender and sexual orientation. In terms of gender, are you transgender, genderqueer, or gender fluid? Some of these terms might be new to folks, but it's basically giving kids options in how they want to define themselves, right? Roughly 3% of 8th, 9th, and 10th graders each said yes to that question. So to put this in perspective, in one of our lawsuits that we filed, we noted that the school district that we sued had 5,700 students. So 3%, that's 171 kids. The other thing we know from the survey is this isn't a Twin Cities thing. This is throughout the state of Minnesota, rural, urban. It goes across white kids, Native kids, Black kids. It's not a white Twin Cities urban thing. We also know that transgender and gay, lesbian students are more likely to report bullying, and they're far more likely to report suicide attempts. So in the 2016 study, and that's a pretty big year in Minnesota on this issue, and we'll talk about that. Bullying was 14% for kids who self-identified as heterosexual, compared with 30% for kids who identified as gay or lesbian, and 15% for cisgender kids, compared with 36% for transgender kids. Suicide attempts, 16.3 for heterosexual kids compared with 54% for lesbian and gay kids, and 18.8% for cisgender kids, meaning kids who are not transgender, compared with 55.4% of transgender kids. And just to be clear, there's nothing about being transgender that makes you more likely to commit suicide. That's not what's going on. Studies show that many of these issues are actually attributable to discrimination, lack of social supports, and rejection. And studies also show that the risks are reversed when you allow kids to socially transition and live authentically as themselves. And so some kids do medically transition, meaning they take hormones, they may take puberty blockers, right? Some kids do that. Some kids start off with socially transitioning, where they may have their hair a certain way, go by a certain name, go by a certain pronoun. When kids are supported in these decisions, it actually changes mental health outcomes. And there are studies that support this. I do want to be clear before we move off of this topic that transgender kids are not new, that the topic's being talked about now more than ever. There's states across the country, I think over 36 states tried to push bills to ban trans kids from playing sports. States were pushing bills trying to ban trans kids from getting access to gender affirming medical care. And the way they're doing this is by claiming this is something new. When you hear people talking about trans kids as though they're new, I want you to stop and interrogate that. Just because people are talking about it now doesn't mean that it's because it's just suddenly happening. Your kids have probably shared bathrooms and locker rooms with transgender people across the state of Minnesota. No one waits for a court to tell them where they can pee before they pee. Let's just put it that way. And the fact that you may not know that you've done it, I think the issue there is that it's just uneventful. And so all of the fear mongering and stuff, I want you to stop and interrogate it and think like, not what will happen, right, if trans students are allowed to use the bathrooms and locker rooms that align with their gender identity, but what is happening, because all across the country, transgender students have been allowed to use bathrooms and locker rooms that align with their gender identity. And the answer is nothing. And same with sports, right? Trans kids have been participating in sports. The Minnesota High School League is trans inclusive. And what we found is that was around 2015 or so. There was a lawsuit to allow 2 cisgender boys to play on a girls' dance team because there was no boys' dance team. The judge in that case, as part of that lawsuit, analyzed like what are the girls' participation rates in the state of Minnesota, right? Because that's how you analyze a Title IX claim saying, there's discrimination against based on sex in sports. So one thing you can look at is participation rates. And the court looked at participation rates from 2015, which is around when the Minnesota High School League formally adopted gender inclusive policies, to the present, and found that girls' participation rates have been like on the increase and are actually higher than boys' participation rates, right? So that's an example of stopping and interrogating, right? Like I hear, trans girls want to play girls' sports. Wait a minute. Trans girls are playing girls' sports. What does it look like? And that's true in Minnesota. It's true in California. There's been studies that show actually that in states that have trans inclusive policies, girls' sports participation rates are actually really high. And so I just want to make sure as we go along that even though this topic is being talked about and it might be new to you, it's not new. Trans kids aren't new. Medical interventions for trans kids are not experimental or new. And I just want folks to keep that in mind. And when we talk about the future of trans students' rights, just remember, like, trans students have rights now. They've been doing the things that they want to be able to do. And it's, you don't have to like speculate, like you can look at what does it look like, and it just looks like kids being kids.
Thanks. I wonder, and maybe this is a combination of Cheryl and or Jess to answer this question, and this is also a huge question that let's dip into before we go on, but how are Minnesota school districts addressing the rights of trans kids right now? Would you say generally, obviously it's different, hit or miss by different school districts, but can you give us an overview of that?
And I'd love for Cheryl to weigh in. I will say most Outfront does a lot of work on this. We do a lot of work on this as gender justice. And when legal issues arise, most of the calls in Minnesota get routed to our way. We are getting inundated with parents of transgender and non-binary kids who are having issues with bullying, with harassment, with school officials being resistant, with pronouns, with names. It seems like this year is worse than ever. And I can come up with a lot of plausible explanations for why. I think the national conversations we're having around like trans youth, treating them like they're sexual predators and not children, right? Like, I think that's really contributing to a lot of the problem. People are being sent into school board meetings to just go nuts about trans kids and critical race theory and stuff. And it's people kind of acting like a problem that's not really there. But we are being inundated with calls. I will say there are schools that are getting it right, and they're not necessarily like, you know, in Minneapolis, like there's schools in the Iron Range that are really committed to getting this right. There's schools around the state that are committed to getting this right. I think schools right now don't have an option. David, I know we'll talk about this, but they do have to allow trans kids to use the right bathrooms and locker rooms, meaning the bathrooms and locker rooms align with their gender identity. That is the law right now. And so schools have to do it, but whether they're doing it willingly is a different question, right? Schools may like have their administrators put their pronouns in their bios, but then they're not like getting the kids' names and pronouns right. You know, it's really all over the place. And I think it just shows like having laws and policies are not necessarily going to reflect how the kids are treated. And I mean, a good example of that is when I was sworn in New York City. New York City has long had human rights protections for gender identity, gender expression. I got like physically grabbed and pulled out of the line at my bar admission because I wasn't wearing a tie, and they thought I was a boy not wearing a tie, which was part of this gender dress code they had. And it was like in front of my mom, in front of my friends, right? And this is in court. This is like in the courthouse. And so you can have a law, you can have a policy, but you still need to do more to make sure you're actually getting it right. Cheryl, I don't know if there's stuff you want to add from your experience training schools.
Yeah, I'll just say that so we work all over the country, and we certainly are getting a ton more requests for training in Minnesota and not in the Twin Cities area, which is great. And I think what ends up happening is states that have really good enumerated policy in place, when it comes to actually doing it, you need the good professional development. Otherwise, educators are like, okay, we've got these policies. I don't necessarily agree with them. I don't even understand why we're doing it. And so we help fill in the why these policies are enumerated the way they are and why they're important. So the combination of having the professional development with good enumerated policy really, I think, it is the key. And yeah, we've been, interestingly, we've been getting a ton of requests from, it used to start with, it was parents, like we've got kids and we need the help. And now it's administrators that are actually reaching out to us. We've done a lot of work with the Minnesota Association of Elementary School Principals, knowing that we know we have these policies and they have educators that either are unwilling for whatever reason to do the right thing, and they know that they have to. So, you know, that sort of fills the gap.
And we do have a tool. If I could just real quick, we do have a toolkit on our website. If there are any parents here of trans and non-binary kids who want to know, like, you don't necessarily want to engage legal counsel, but you want to be able to advocate for your kid or your niece or your nephew or whoever it may be. If you go to genderjustice.us/back-to-school, it'll take you over to our toolkit where we do actually say in our toolkit, you might want to get affirmative training before you get sued and it's more expensive. But we do have that toolkit available if folks want to take a look. But I'm sorry, David, please go ahead.
No, I think that's exactly right. I was going to sort of tag along to what Cheryl was saying, which was, I think it is important that as we talk about the future of transgender student rights, part of the future is, you know, hopefully giving folks on the call a takeaway to what they can do in terms of pushing this issue forward. And I think going to the toolkit that Gender Justice has, to making sure that people are advocating for their students' parents, or calling the school board, calling the administrators, like Cheryl suggested, and insisting that they have good professional development and good policies. I was going to say that this summer we ended up at the ACLU doing just an informal survey across the state to see what policies are in place in terms of facilities use for transgender inclusion. And Cheryl, this probably doesn't surprise you very much, but we found that over 97% of public school districts in the state don't have any policies around transgender inclusion when it comes to sports facilities, usage, locker rooms, bathrooms, or sports teams. And so, you know, I think certainly the baseline is, you know, get the policies in place, and then also have good professional development and training, sort of implementing and monitoring those policies to ensure that school districts are complying with them. So we've got some work to do there. I just wanted to jump in and say that.
No, that's great. And this is such an important topic. And thanks. I'm seeing comments and really good questions. I'm going to try to synthesize one of those before we move on to the kind of the legal nitty gritty, which is why we're all here for the CLE credit especially. But maybe Cheryl, you can address this. We have a question from someone: for schools and teachers that want to be gender affirming, but who fear backlash from parents, how do you help give schools or teachers the courage to do what they believe is right?
Yeah, it's a good question. So here's what we'll say. We work with schools in the Deep South, in rural red areas all over the country. And here's our framework. As an educator, it's your job to ensure that every one of your students can thrive, not just some of them, all of them. And that's our basis. And then what we say is you get to have your own religious, moral beliefs and values. Those are yours. But as an educator, you also have the obligation to make sure that every one of your students can thrive. And that means addressing students as they'd like to be addressed, using the pronouns that align with their gender identity, using the names that students align with. So all of that. And again, it's about, for us in the world of education, putting that front and center. Like, that's actually your job, not to help some kids do well in school. All of them, that's your job. And you do have kids that are trans and gender nonconforming and LGBTQ in general. And they're your kids too. And it's your job to help ensure that they thrive. That tends to move the needle a bit with some. Yeah.
Yeah, that's very helpful. Well, let's pivot here and kind of get a history lesson about the Minnesota legal landscape and kind of how we got to where we are today. And David, maybe you could start us off here talking about, Minnesota was one of the first states, if not the first state, and I'm not sure, the first, to have a comprehensive Minnesota Human Rights Act. It's from 1993. Minneapolis was even earlier. But David, could you kind of just walk us through what protections are included in the Minnesota Human Rights Act and how that's been used in litigation?
Yeah. So the Minnesota Human Rights Act was enacted, like you said, in the the Minnesota Department of Human Rights came along in the 1960s, and by the 1970s, you had what we refer to now as the Human Rights Act, which is codified in 363A of the Minnesota statutes, Chapter 363A, for those lawyers who are interested. And the purpose of the Human Rights Act is to secure for persons in Minnesota freedom from discrimination, plain and simple, and to ensure that such discrimination that threatens the rights and privileges of Minnesotans are eliminated. And I think it's important when, Jess loves to, I love it when Jess reminds us that, transgender students have been around forever. In addition to that, we also should be reminded that discrimination has been around for a long time, and so have the efforts to try to eradicate that from our society, to try to appeal to our better senses. And so the Minnesota Human Rights Act comes along in that framework. And under the Minnesota Human Rights Act, you also have established the Minnesota Department of Human Rights, an actual agency, a government agency that's set aside and that's tasked with enforcing the rights of all Minnesotans to ensure that they are free to walk around without being discriminated against. And its head is the commissioner of the Human Rights Act, who's right now is Rebecca Lucero. And the commissioner is charged with formulating policies to accomplish the Minnesota Human Rights Act purpose of securing freedom from discrimination for Minnesotans. And what's important here is I think this also means that because there's an agency that's explicitly set aside for enforcing the Minnesota Human Rights Act, they have broad authority to seek implementation of policy changes and requirements on, for instance, school districts. We'll talk about some of the cases in a little bit, I'm sure, and some of the sort of settlement and relief that we've been able to get. But under the Minnesota Human Rights Act, and because it's the Minnesota Department of Human Rights, they're able to seek broad relief that's beyond just monetary. that incorporates into that, policy changes, that incorporates into that reporting and monitoring for, so that there's some teeth to some of the enforcement of the laws. And of course, the Minnesota Department of Human Rights is not the sole enforcer of the Human Rights Act. Individuals can enforce the act themselves. They can enforce it by going to the Minnesota Human Rights Department and asking for assistance in filing a complaint and having them investigate, but they can also go straight to court. And in fact, I think the cases we're going to talk about today, at least in one case, maybe two, that was the case. The individuals went to court. In one case, it was because the Minnesota Department of Human Rights, like many, unfortunately, like many agencies throughout the country who enforce anti-discrimination laws, are understaffed and underfunded, and so they don't have the capacity oftentimes to investigate everything that's been given to them. But in this case, that's individuals in Minnesota can go straight to court. You also mentioned in 1993. Sexual orientation was included in the Minnesota Human Rights Act. And as a part of that, it included gender identity as part of the statute. And it was broad in terms of its application. So the Minnesota Human Rights Act has a lot of different categories that it covers, including public accommodations and housing, employment, education. And the sexual orientation provision applies to all of those. It explicitly bars discrimination based on having or being perceived as having a self-image or identity not traditionally associated with one's biological maleness or femaleness. So broad protections under the Minnesota Human Rights Act. Hopefully that gave a little bit of background. I don't want to, I love that actually Cheryl brings in sort of the practical education piece, and I was sitting there like taking notes from her, so I don't want to be get too into the legal landscape, but hopefully they give some background.
No, that's perfect. And I think let's use that to just talk about recent cases, because I think through those recent cases, we'll kind of learn kind of how this is used by litigants, and both through the Minnesota Human Rights Council and, as you said, individuals that take it straight to court. So David and Jess, you are two of the lawyers that were involved in NH versus Anoka-Hennepin County. And maybe you can tell us about that case. First, just starting with maybe the background in Anoka-Hennepin, because it kind of starts before this case even was brought to any court. Or so I don't know, of the two of you, who wants to take a crack at that? Oh, Jess, you're muted, or we're not hearing you.
How's this?
That's good.
A year and a half into the pandemic, I'm still like always on mute. So Anoka-Hennepin is not the first school. I mean, I'll just start with Anoka-Hennepin. So Anoka-Hennepin basically had a bunch of, there was a lot going on at Anoka-Hennepin. They had basically rules that you couldn't talk about anything LGBTQ related. This kind of fake neutrality where it's like, if you don't talk about it, it's neutral, which we know is not true, right? Like there are LGBTQ kids at the school, there's LGBTQ kids in history. It's hard to see how you get a rounded education without mentioning LGBTQ stuff, but that was the school's policy. They had issues with bullying, but it was very severe, and they weren't really doing enough to step in. They were sued by a number of national organizations, I believe. I want to say Fagery. There were also local law firms involved that sued Anoka-Hennepin after there were a number of suicides. I want to say it was something like 7 to 9 LGBTQ kids committed suicide in the school district, which is horrendous. That case went through the courts. It ultimately settled, and the school was put under a consent decree where they were monitored by the Department of Justice. And they had to do a number of policies. They had to make a payout, right, of over $200,000. They had to implement policy changes, which I read somewhere cost upward of $500,000. And they were being monitored. While they were being monitored, our client, who I'll just refer to as Nick, was going to school in the school district at Coon Rapids, and he was on the swim team, and everything, to the school's credit, everything was going well, right? Like, he was swimming on the boys swim team. He's a transgender boy. He was using the boys locker room. He was using the boys bathroom. No one complained, no incidents. And we know this because this case, we litigated this case through the MDHR, the Minnesota Department of Human Rights, into the courts. At no point did anyone claim that there were any complaints, but a school board member, basically people went around to school board meetings with this really bad legal memo. It was, and I'm looking at it right now. So I'm going to say his name because it's on this memo that I'm looking at, right? Doug Wardlow and the Alliance Defending Freedom sent a memo out to schools all around the state, and I have a copy, it's available online, giving really terrible legal advice saying that it's discrimination against cisgender and heterosexual kids to be at all LGBTQ inclusive. It was basically a response to the Minnesota Department of Human Rights toolkit, which encouraged schools to be accepting and helpful and positive towards LGBTQ kids. That toolkit is still available, but it hasn't been updated with the most recent cases. And so school boards were getting these letters, and parents were coming to school board meetings. This issue just got kind of blown up, but not by like kids within the schools having issues with like trans kids in locker rooms, but by outside parties. A school board member asked the school, "Hey, do you have any trans kids using bathrooms or locker rooms?" At first the school said no, and then they were like, "Oh wait, yeah, there's one," and the school board made them stop. From there, the client started to experience bullying, harassment. He was allowed to continue on the swim team. He was kicked off. He was allowed back on. It was a huge problem. The school ended up building a separate locker room. They called it an enhanced privacy locker room, but the kids called it, the tranny locker room. Let's just be real about what was going on at the school. And it caused a lot of pain. He was the only student required to use it. So we brought our case, and David, do you want to talk a little bit about the case, since I just went on?
No, that's great. That's a great description. And, so as we brought the case, I think it's important to mention, just to get a little bit more law in here, is that the school board, in defending the lawsuit, relied heavily on a Minnesota Supreme Court decision called the Goins decision. Goins versus West Group 635 Northwest 717, which was decided in 2001. And in the Goins decision, a employee at West Publishing a trans employee wanted to use the restroom, and was told they couldn't because they needed to use the restroom that conformed with their biological sex, or what was perceived as their biological sex. And so in that case, Goins considered whether a private employer's policy requiring restroom use based on sex discrimination against a transgender employee was in violation of Minnesota statute section 636A 03 and then subdivisions. But it's specific, particularly what's important here is that it was the employment anti-discrimination provision that the court had to consider. And in relying on that, the court had adopted a holding that basically held that an employer's designation of employee restroom use based on biological gender is not sexual orientation discrimination in violation of the Minnesota Human Rights Act. And that's what the school district had relied on, or purported to rely on, to say, well, we can do what we're doing here. We can actually separate folks out and designate that they use a particular bathroom. And that was what they relied on. So when we sued them, that was what they had put forth for us. In the district court held, that Goins was not binding precedent. One, because it did not, and most importantly, because it did not involve interpreting the statute under which the school district was operating, the education anti-discrimination statute, and because the Goins decision was narrowly looking at an employment situation, not an education situation, among other things. We brought the suit under both the Minnesota Human Rights Act as well as the equal protection provision of the Minnesota Constitution. And in both claims, the district court found that the school district had violated a NICS rights. And that was really sort of in the district court. This decision then went up to the appellate court, the Minnesota Court of Appeals. And in the Minnesota Court of Appeals, it was affirmed. The Minnesota Court of Appeals holding was that a transgender high school student who was denied use of a locker room and is available to students of the gender with which the student identifies and to which the student has socially transitioned, states a claim upon which relief can be granted of sexual orientation discrimination under the relevant statutory provision. And in addition to that, it states a claim under the Minnesota Constitution equal protection provision found in Article 1, Section 2. And that intermediate scrutiny is the correct standard to be applied to equal protection claims that hinge upon a sexual orientation discrimination claim. So that was not, what's important to know is that what the Court of Appeals did was not earth-shattering, because there were certainly other cases in Minnesota that had been settled by school districts on those issues, and throughout and we're going to talk a little bit about sort of the national landscape, but throughout the country, this was also being litigated, and the Court of Appeals was finding the exact same thing that the courts throughout the country were finding.
Thank you. And before we do move to the national landscape, I thought I'd just take one question from the Q&A section, and maybe Cheryl, you could weigh in on this. And all of you, I'm interested in your thoughts, but given that Nick's case had to do with the locker room, we have a question about, is there a concern over straight students and feelings of embarrassment if they shower with different genders? And how do you balance, what's the balance there? I think if we're talking about kids, I can just give my personal perspective from having a sophomore, that nobody likes to shower in any sort of situation in high school or junior high. But Cheryl, what are your thoughts on that?
Yeah, I agree. I think that's an issue for all kids. I taught middle school physical education for many years. Nobody wants to be dressed in front of other kids, especially trans kids don't want that. So they want, so the idea is you should have areas where kids can dress privately. Any kid can dress privately. The thing is just not to make it about, oh, the trans kids need to use this. There are many kids for many different reasons that need privacy, or that want privacy, or that should have privacy when they're changing. So this whole issue of creating something because someone is trans just is a bit of nonsense. And I'll just add and go back to your lawyer stuff, but I'll just say with Anoka-Hennepin, they actually brought us in because part of that settlement was them having to do professional development. And when we came in, we worked with every single teacher in Anoka-Hennepin over the course of 2 years. And we're supposed to do a training around creating LGBTQ inclusive environments. And they made us water it down so much that it was more about values and how other people can have different values. And it was like totally not anything that they needed. And teachers were afraid when they'd ask us questions, they were afraid to do the right thing, afraid of getting fired. So just adding that piece of context to what was happening in Anoka.
Mm-hmm.
What's also very interesting, and Jess, I know you want to jump in here, maybe even flesh out a little bit more about the settlement for NH, because we ultimately, after the Court of Appeals decision, did settle the case. What seems to be one through line or one common theme in H and in other decisions around the country is that school districts, what they end up doing is start having these privacy areas, like Cheryl said, but then designating those privacy areas only for transgender students to use. And so it seems to cut against sort of this this sort of argument or this idea that you want to sort of protect people if you're not allowing the folks who may want privacy to actually use the privacy spaces, and allowing the people who don't want the privacy spaces to use the open areas. And so there is sort of we'll talk about other cases, but it seems to be a common theme in many of the cases that this is what ends up happening.
Jess, I was just going to ask if maybe you could kind of expand on that, talk about the settlement, and then talk about how NH is being used in other settlements, like the case that we had with you, and perhaps how you see that application of law that was recognized in NH going forward.
Yeah, so NH was actually not our first settlement. We did represent a 5-year-old and her parents against a school, Nova Classical Academy, that the lawsuit's public. You can look it up online. She is transgender. She was being bullied. She was the school was not willing to adopt gender affirming policies. They weren't willing to relax their dress code. And, real issues came up when she wanted to basically ensure that her fellow students and her teachers referred to her using the correct names and pronouns. The school sent out a letter to all the parents, giving them an opt-out option. It was just a mess because they didn't really have policies in place. And so we sued them, and that settled outside of court for $120,000 without any litigation. And so that case did involve the school having to adopt policies, which they did. Like right now, the Nova Classical Academy has adopted, they've done what they're supposed to do under the agreement. So this was a few years back. I'm not trying to speak to what they're doing now. So they did adopt policies. They set up trainings, right? That's among what we asked them to do. And with the NH case, the Minnesota Department of Human Rights intervened on the NH case, on Nick's case. And so they were parties. And so they were able to negotiate policy changes that they could actually make sure the school was implementing, such as, making sure kids are allowed to use the right bathrooms and locker rooms, using the right pronouns and names and all of that. And because MDHR stepped in, they did play a role in negotiating the policy outcomes. And it is, on top of having to pay our client, on top of having to pay out $300,000, they had to adopt all these costly policy changes. And as Cheryl said, it would have been probably cheaper for them to have, well, that was Anoka-Hennepin, so they already had training and policies. So it would have been cheaper for them to maybe stop engaging in the thing I was talking about earlier, where you look at hypothetical what ifs, right? Like, what if we get sued by a parent of heterosexual cisgender kids who, claim that we're doing something wrong by being trans inclusive? Like, if that kid sued you, they probably lose. Time and time again, when the trans kids sue, they win. And I'm not just saying that, this is just objective, and we can go through all the cases all around the country and in Minnesota. So we also had another case in the Buffalo Hanover Montrose School District that we litigated with Amy and Katie with Bess and Flanagan. Basically, that case was going on around the same time as Nick's case. And so when the Court of Appeals decision came down affirming that trans students are protected under both the Minnesota Human Rights Act, which there was a question earlier about private schools. The Minnesota Human Rights Act does apply to private schools. Okay. So he's protected under both the Minnesota Human Rights Act and the Minnesota Constitution, which is so important, right? Because that protects us from discriminatory legislation. We were able to resolve the Buffalo Hanover Montrose School case, and that was $218,500. It's a public number. Lawsuits against public schools, the amounts are public, along with costly policy changes. But that precedent, as everyone knows, you're all attorneys, and you may have seen from the Noor litigation that took place over the summer around third-degree murder, when the Court of Appeals makes a ruling, it is precedential and therefore binding. Okay, so the Court of Appeals has ruled. It hasn't gone up to the Minnesota Supreme Court, but that doesn't mean that it's not binding, right? We know this. And so that is a binding ruling. And so we were able to use it in that other case. Unfortunately, we continue to get calls from schools who just have it in their heads that they're going to be sued for being trans inclusive, when if they actually stop and look at the reality and stop reading these legal memos and other nonsense, if they stop and look at what's actually happening on the ground, they will see in Minnesota, schools are paying out. In Wisconsin, right, in the 7th Circuit, in the Whitaker case, the school paid out $800,000 for discriminating against trans students. In Virginia, in the Fourth Circuit, Gavin Grimm's case hit the Supreme Court twice. They refused to review it. Gavin Grimm won, right? He wasn't being allowed to use bathrooms and locker rooms that aligned with his gender identity. The school paid out, I think it was $1.3 million, right? Because it's attorney's fees. It's costly. And so,
Jess, can I mention one thing while
Absolutely.
you're talking about Grimm? I just think it's important. You were underscoring the fact that the Supreme Court refused to hear the appeal of the case. And this is after the Fourth Circuit said in their opening brief, at the heart of this is the appeal is whether equal protection and Title IX can protect transgender students from the school bathroom policies that prohibit them from affirming their gender. We join a growing consensus of courts in holding that the answer is resoundingly yes. And so the Supreme Court left that in place, just to be clear. And so I think it's, it is certainly, and the court is right there, that the growing consensus of courts, both courts of appeal who have looked at this particular issue, as well as those who have looked at issues related, including, we can talk about Bostock and, maybe at some point, who have looked at employment issues and other issues related to, related issues, that transgender inclusive policies are being affirmed.
That's right. And those federal cases are Title IX and the US Constitution. So right now what we know is that most circuits who've been asked whether Title IX protects trans people have said yes. When they've been asked whether the Equal Protection Clause of the federal Constitution protects trans students, most courts have said yes. The Minnesota Human Rights Act protects trans students, and the Minnesota Constitution protects trans students. So I'm not sure how much more there is to do at this point. But for some reason, schools really have it in their heads that they're going to be sued by a cisgender student who opposes gender affirming policies, and they're going to lose that case. And it's just not what's happening on the ground.
And then it's important, Amy, to also mention, and sorry, we may be getting off. You'll keep us back to where we need to go. But it just mentions these cases, and it's important to know that if you look at them, there's a number of different arguments that have been advanced. So if you're sitting on the side as a parent and saying, well, maybe they just didn't argue about the privacy of students. They did. Those were advanced.
They expressly lost that one.
And rejected. Yes. So I think we should be clear that it wasn't like these were very robust litigated cases in which the court had considered, particularly it's the privacy argument that I think, or the privacy concerns that parents, maybe bring up, and that's just not a legitimate reason to discriminate for someone, right? So I just wanted to reference that as well.
Yeah, and we want people to care because they care about trans and gender nonconforming kids. We're just attorneys, so we're talking the law. And for some reason, schools aren't getting. Sometimes the hearing about the money and all the consequences can make that difference for the school board that's not sure what to do. And because we're hearing so many problems, despite all of these courts saying you can't do this, it's just worth raising. But what we really want is for people to care about trans kids because they care about trans kids. So
I just want to go back to Minnesota for a second, and then you both just did a great job of talking about the federal, giving a little teaser for the federal stuff. And, there's so much to talk about here. So maybe we'll go in a bit there. We do have a couple follow-up questions on the Minnesota state cases. And you mentioned this a little bit, Jess, that the Nova School settlement, and that also that, private schools are also obligated to follow the same, obviously the Minnesota Constitution and the Minnesota Human Rights Act applies to private schools as well. We have a question about charter schools and whether that makes it more difficult due to their smaller size and less access to legal counsel, or in cases like Nova, schools having maybe particular political views, maybe concentrated within a school that they're sending their kids to for a particular reason. Are you noticing any difference between the application of these to charter schools or to private schools? And maybe just reiterate that a bit. How about Jess?
I'm wondering, this might be a good one for Cheryl. I mean, all I can say is like Title IX applies to schools that receive federal funding. So if you're at a school that receives federal funding, if you're a school that does not accept any federal funding, Title IX may not apply. But the Minnesota Human Rights Act still would. Minnesota Human Rights Act is not dependent on receiving state or federal funding, and the Minnesota Human Rights Act does not have an exception for private or charter schools. We've been getting a lot of calls from students at public schools. That doesn't make me think that private schools are necessarily doing better or worse. But I don't know, Cheryl, are you getting calls from private and charter schools?
Yeah, absolutely. We do a lot of training in independent schools, charter schools, and some religious schools. So I don't know if they're, legally how this pertains to religious schools. I'd be interested to hear what you have to say about that. But certainly there are a growing number of religious schools as well that are trying to do the right thing. I don't know how the laws pertain to that, though.
For religious schools, you can look at 363A.23. It's specifically for a religious or denominational institution. So here, let me see. The provisions so that the education provisions shall not apply to a private educational institution or branch or level of a private educational institution in which students of only one sex are permitted to enroll. There's not like anything in here that would allow, that's the exemption based on education in the Minnesota Human Rights Act. Again, that's 363A.23. So I don't believe that religious schools are necessarily exempted from these requirements. I think they might be able to raise rights they might be able to raise their rights. The Minnesota Constitution, we don't need to go into this, but RFRA is the Religious Freedom Restoration Act, which says that even if there's a neutral law that applies to like everyone, it still gets strict scrutiny if someone raises a religious claim, right? And so RFRA applies to federal laws, though, and the Minnesota Human Rights Act is a state law. But the Minnesota Constitution has like a built-in RFRA. Basically, our courts have said that we have all, we don't need. Basically, our courts have said like we don't need a separate statute. We don't need a RFRA. If someone's bringing a religious liberties claim, strict scrutiny applies, even if it's a neutral law. How the court would apply that balancing test, though, like a lot of people talk about religious liberties as though like I'm religious, okay, done, right? But it's a balancing test, right? You weigh the government's compelling interest in preventing discrimination, against other interests, right? Is it narrowly tailored to achieve a compelling government interest? So just because this comes up all the time, right? If you're a religious pharmacist and you don't want to give out emergency contraception, you can't necessarily just decide not to do it because you're religious, right? Like if there's a law that says you have to do it, the courts can weigh whether the law is important enough and narrowly tailored enough. So if a religious school wants to discriminate, I mean, they might end up having to bring a lawsuit, and that would have to be determined by the courts. But right now, it's schools can, religious schools can allow admissions by certain students of a certain religion. They can be like single sex schools, and but yeah.
Let's kind of move to the federal landscape. We've talked about Grimm. And I see that Katie put Grimm in the chat. So for those of you who want to review that opinion, you can. We gave you the kind of like really high level explanation of it. And David, maybe you could kind of tease out what, Grimm was based on Title IX and the 14th Amendment. What arguments were made that the Fourth Circuit didn't agree with in finding that there was a protection for Grimm?
Yeah, so I mean, the primary argument that was put forth in Grimm, and Grimm was this was also another high school case. Gavin Grimm was a high school student at the time who was denied access to the boys' bathroom, and the school, which there was actually an extensive, again here, I believe it was 7 weeks. Grimm used the boys' bathroom without any incident, and then lo and behold, so this should sound familiar because it sounds a little bit like NH, right? The school board heard about it and said, well, you can't do that. And then they actually, the school board had a number of hearings, which got in the record, and there was some very nasty things that was said during these hearings that the court made note of in their decision as well, including parents who referred to Gavin Grimm in derogatory terms and things, and so indeed one of the things that the court makes note of is a threat by many of the parents who told the school board, if you vote for inclusive policy, we'll vote you out. And indeed, they didn't vote. They voted for an exclusionary policy, and so there was a record built that suggested there was more going on. There was more going on here than sort of to just getting back to Jess's point, looking at the well-being of the student or the Gavin Grimm, right? So that was sort of the record there. And one of the arguments that was primarily raised was around sort of the privacy interest. Other students, what would they do? Again, in this case, they built additional privacy stalls, but ultimately ended up telling Gavin that he had to use the girls' bathroom, and only Gavin. So the argument around privacy, the court rejected, in part because of the nature of the privacy interest, and that they had already built privacy areas in which Gavin could use in the boys' bathroom. So if you're concerned about privacy, you've got a privacy area, privacy stalls that were different than in H, where it was in a whole separate area. This serves the purpose, so why don't you honor it? Until the court rejected that outright. And then there were some technical arguments made about whether Title IX would apply because it uses sex, and does that include gender identity or not? The court reasoned that it did, and was following stock with Bostock, the U.S. Supreme Court decision, who had already, while saying explicitly that they were not going to rule on whether Title IX was inclusive of a bathroom issue, did find that in the Title VII context, which is an employment anti-discrimination statute, that when Title VII uses the term sex, that it does include sex stereotyping, and it provides protections for transgender students, even if that wasn't explicitly what the legislature had intended at the time when Title VII was enacted, because of course, what's more important is that when Title VII was enacted, the legislature's design was to eradicate discrimination in the workplace. And so the Grimm decision picks up on that line of reasoning and answers affirmatively that yes, of course, even if Title IX does not have explicitly the protections, or was not envisioning that at the time, it certainly protects transgender students in keeping with the rationale and logic of Bostock. So I think those were the two primary arguments that were raised. If I'm missing any, I apologize.
No, that's great. And thanks for bringing up Bostock too. And someone brought up a comment earlier that there's this umbrella term of sexual orientation under the Minnesota Human Rights Act. And to me, that sort of reminds me of what happened in Bostock too. It's like, I mean, in Minnesota, it's pretty explicit that it applies to gender as well, but it was a term in 1993 that maybe today we don't think of as encompassing gender identity, but it does. And Bostock was a 6-3 opinion written by Justice Gorsuch. So there's also kind of this strict originalism that's happening in terms of, this is what it says, and this is what it's going to mean. So I'm cognizant of time. I think for those of you who can stay, I'm going to take us a little bit over to make up for the time we lost. But I want to get into the trends we're seeing. And we all know what they are, because they are very political right now. We're kind of in this heated moment where school boards are becoming kind of a battleground in some ways. We've had a bunch of questions about sports and sports access, and the transports bills we're seeing. So Jess, can you kind of give us a, short guide through that landscape and what we're seeing? And I'll just say, there's nothing new under the sun. And Jess, maybe you could start there, that while we might be hearing about it more now, this isn't new. And so where do we find ourselves now?
Doing this short is really hard. I could go all day on sports. I will say, for the religious thing, just really quickly, because my brain's not going to let this go until I say it out loud. I was answering the question about a religious exemption for secular schools. For religious schools, there is an express exemption based on sexual orientation, but that is 3638.26. And it's more just like the Church of St. Mary on the corner also runs a school, not like I'm a school and I'm religious. So it's really specific, but if I didn't say that caveat, my brain would just like never let it go. So there, I've said it, I can move on to sports. So in this past legislative session, we've seen, I believe it was over 36 states push bills to ban trans girls from participating in girls' sports, specifically trans girls sports. Idaho passed theirs before all of this onslaught. That bill is currently enjoined. So Idaho passed a bill basically, calling for like anyone can question the gender of anyone playing a sport, and then a girl, and then that girl would have to go get like a genital inspection. I mean, just terrible. Like, what girl wants this, right? And if you look at me, right, like I played girls sports my whole life. People might say, oh, that's a boy, and then I have to go get a genital inspection, right? It's not something that it targets trans kids. It's terrible for trans kids, and it's terrible for all kids. And we have seen actually parents call out girl athletes and demand this, and the girls are not transgender, or there was a situation in Arizona where a bunch of parent activists were complaining about the student on an opposing soccer team, calling her trans, and went to, I think they talked about it in the legislature, and it turned out the girl was not trans. And so Idaho passed their bill. It got challenged. It was enjoined, meaning it's on pause. We're waiting for the Ninth Circuit to decide whether that preliminary injunction should hold. And so Idaho was the first, but other states have followed. There's lawsuits, I believe, in Florida and West Virginia. And so what's going on? Basically, when these bills were being introduced in state legislatures around the country, the legislators introducing them were asked, hey, can you name a trans student in your state? And they all said no. Trans athletes, first of all, in 1970, 77 or something, Renee Richards, a trans tennis player, sued to be allowed to play women's tennis, and she won. And we always say, like, she won in court and then lost in court. Like, she won her court case and then like immediately lost in the women's tennis match. But trans athletes have been participating in sports. The Olympics have been trans inclusive since 2004, and we saw our first openly trans athlete compete. I believe she got last place, Laurel Hubbard, in weightlifting. And so all of these legislators introducing these bills could not point to, I mean, there aren't even enough trans girls in their schools who wanted to play sports who could like fill all of the sports teams. I mean, it's just ludicrous. And none of them could name a problem, none of them. And what they all named was a case in Connecticut that got dismissed. So in Connecticut, a girl who got 5th place in a track meet sued a trans girl who got 1st place in a track meet, and sued the school, actually, didn't sue the girl, basically saying the school discriminated against me, the cisgender girl, by letting the trans girl run girls track. That case got dismissed after the students graduated. The cisgender, what the cisgender girl didn't mention in the lawsuit is, like, right after filing the lawsuit, she was complaining, oh, this trans girl's always beating me. She won the next race, right? And she went on to get an NCAA scholarship, while the trans girl is not currently running on an NCAA scholarship. So it's like all of these like what ifs, they're not playing out, and it's not new that there are trans athletes, right? So it's back to that. Interrogating what people are talking about when they're talking about sports. We see the bills attacking trans athletes as being, and including in Minnesota, right? Minnesota had the harshest one where they wanted to throw trans kids who play sports, send them to juvie, send them to the juvenile detention courts. And as someone who's represented kids in juvenile proceedings, the judge says, why don't you participate in a pro-social activity? And the kid then has to say, I'm here because I participated in a pro-social activity. Just ludicrous. And so Gender Justice spent a lot of time pushing that back, and we know those bills are going to be reintroduced this next session. And so what's going on? Well, these bills are being introduced alongside, they're not being introduced alongside bills. They're claiming to protect women's sports, right? But they're being not introduced with bills that would increase funding, right, for women's sports in public schools, let's say, right? Like most girls get access to sports through their public schools, right? It's free programming. So these bills aren't being introduced with like, let's shore up, the money, the funding. Let's make sure these programs are equal to the boys' programs. Let's protect the girls from sexual harassment. They're being introduced with bills that would ban trans kids from getting gender affirming care. They're being introduced with bills that would prohibit trans people from changing gender markers on their birth certificates. And they're being introduced with abortion bans. Right, because these organizations are basically working together to introduce bills around the country on their pet topics, which are controlling, like ending abortion. And you can't end, right? You can't end transgender kids, right? You can't legislate them out of existence. You could just make their lives really miserable. But that's what's happening all across the country. And we are going to see more bills being introduced as sessions open back up. Texas is currently dealing with this right now. And so I will say, I could talk about this all day. I won't. I feel like everyone's looking at me like, stop talking, Jess. And please just shut me up. But I will say, these bills aren't actually linked to a problem. Like they're not even a solution in search of a problem. They're a problem in search of a problem. And they're not being linked to other efforts to shore up women's sports. And I think that's very telling. In terms of like fairness and stuff, I could talk all day about that stuff. I won't, but Gender Justice does a lot of programming on that. You can follow us if you're interested, but there's a lot to say about that too.
Jess, there's also, just to plug Gender Justice a little bit further, I mean, there's a lot of engagement with the legislature, both locally and like you talked about throughout the states that are going on. And so I'm always cognizant in doing, CLEs and things that folks may want to know, how can I get involved? So I think that's another issue that in addition to calling your school board members and your administrators and telling them to get these policies and professional development programs in place, I think looking at the legislature, giving them some calls and letting them know that you don't support these bills, these exclusionary sports bills, should be top on your list as well.
Thanks. I'm just gonna take a couple questions. And for those of you who can stick with us, please do. We appreciate your willingness to stay with us as we go. The first one, I just want to get your thoughts on, and maybe Cheryl, you could address this first, is how are you seeing some of these precedents applying and policies maybe applying to non-binary students? Are administrators or courts applying these same principles to cases when the gender binary isn't at play?
So I won't answer the court and how they're working on it, but let me just share that what we find is super interesting is that, so when we first started working with schools and we're talking about kids that are trans, educators got that they were trans and they were binary trans, meaning, they were identifying as presenting and identifying as male, got it. Identifying as female, got it. Okay, you're using the girls' bathroom, you look like a girl, all good. Then we get kids that are now they have been for a very long time, that are non-binary. So what bathroom do they use? And I think that it comes back to the point of like, we live in such a binary world. Like you have to be this or you have to be that. And schools are so focused on that. And I think where we try to get with them is, again, they're going to use the bathroom that meets their requirements. And sometimes it could be where they feel safe at certain points of the building. Like they may want to use the girls' restroom at this part of the building because that's where they feel safe. And they may use the boys' bathroom in another part of the building, and that should be okay too. So again, the mindset of needing this to be binary, like you have to look a certain way to use a certain restroom, is what we need to eliminate. You should be using the restroom that you should be using, then only you know that, right? So that's been a struggle. I think that we deal with that a lot. Like, well, I'm okay with a trans kid that looks the way they're, you know, in a very, their gender expression matches that bathroom usage, they're okay with. And, you know, again, needing to really break apart this whole binary concept of what gender is to be able to say they are using the restroom that they belong in, and trust that they are, right?
Right. Jess, are you seeing it at that non-binary kids being addressed at all in any court cases, or courts kind of taking themselves out of the binary?
We have like a lot of calls from parents of non-binary kids lately. That's probably like the main calls we're getting at this point, unfortunately. As far, you know, I don't see any reason why non-binary kids wouldn't be protected. I think, you know, I think some people think like, oh, to help trans kids, we need to have a gender neutral bathroom. And that's not actually true, right? There's trans boys who may want to use the boys' bathroom. There's trans girls who may want to use the girls' bathroom. There's a lot of kids, non-binary or otherwise, who may want a gender neutral bathroom. And I think the key is like to make it available, but not force anyone to use it. And like Cheryl said, you know, I have a lot of trouble. Like when we go on road trips, my wife comes with me to the bathroom because people think I'm a guy in the girls' bathroom and they go nuts. And it's like, people have like physically grabbed me, yelled at me. I've gotten yelled at on a gym tour with a staff member to get out of the locker room. You know, stuff like that happens. And I think we really need to think about the ways these things impact trans kids a lot. And that's the main concern. They really impact all of us. I mean, it's just no one wants to be defined by their like biology, right? Like the glass ceiling, like no one wants to be limited by their like physical body in terms of like, oh, like you have this genitalia, this is what is expected of you in life. Like, I just don't know how that's good for anyone. And so I think non-binary in terms of like litigation, we do get a lot of potential clients with concerns who are non-binary. And I don't think there's anything we would do that's particularly different. We would ask courts to recognize, like, if we have employees who use they, them pronouns, we would ask, you know, hey, like you've got to go along with this. And if you don't, we could bring a claim, because I do think that it's just as valid to be non-binary, or when I was a kid, the term was genderqueer. That was the term I used. And now it's like, I don't hear people using it. Maybe I'm just not cool anymore. I don't know. But you know, like it's a real identity. It's a real thing. And it's, you know, I don't think our arguments would be fundamentally different. I think the thing we try to avoid doing is making arguments like, this trans boy should be able to use the boys' bathroom because, like, look at what a boy, like he's like, this boy is such a boy, he plays video games, right? Like he plays skateboards, like we don't want to really like set those kinds of precedents, and we try not to. But I have not seen a ton of litigation really digging in. The courts are always moving slower than society. So yeah.
One more question, and I'm going to go to this on kind of federal litigation. And is there potential for a circuit split, maybe with the Fourth Circuit on the Grimm case that would end up in the Supreme Court? Are we seeing that this question mentioned a Florida case that denied allowing Drew Adams to use the boys' bathrooms? Do you think that?
No,
you know
Florida ended up, the 11th Circuit ruled in favor of the trans student. So 7th, 11th, 6th, 4th. I would assume like the 5th or the 8th could go ahead and create a circuit split, knowing what we know about the 5th and the 8th. But I don't think there is one right now, like a really direct hit circuit split. I don't think so. Are you aware of one, David?
I'm not. No, I think you're exactly right that in the Adams decision, the 11th Circuit affirmed the district court's finding that it was that the Florida school district's policy was unconstitutional. And so I'm not sure. You know, it's possible, but it does seem to be trending in a direction with both circuits that would be, that, you know, may be considered more moderate, you know, also going in the direction of finding, you know, the same, come to the same conclusion. So I would say it's well, I don't want to jinx anything. So.
All right, well, I want to thank David so much for all of your thoughts today and participating in this discussion. I also want to thank Judge Brian and Katie Barrett-Wick and Rachel for all their help in putting this together. And I should mention that we had a panelist, Irina Vaynerman, who welcomed a baby last week. So she is and the Minnesota Human Rights Council. So she was going to offer her thoughts, but we wish her all the best as she is embarking on this with her new family. So thanks again. I think the CLE code is in the chat. Feel free to reach out to Rachel or to me with any questions. And thanks so much, everybody. Have a great day.
Thanks, everyone.
Bye.